am.
Good morning, Miss Platic.
Good morning, Judge.
What would you give? You give him the day off again?
He didn't let us know until this morning, so I don't know what he's doing today,
Oh, okay.
but I'm here, so.
Okay. Go ahead when you're ready.
All right. Are you Mr. Dillard?
Yes, ma'am.
Thank you. In this matter, Mr. Dillard failed to appear on August 17th of 2023 for a show cause before the referee. This is the first and only bench warrant with bond currently set at $500. Mr. Dillard reports no new employer, and the last payment made in this case was on May 19th of this year through income withholding. Friend of the court requests the next hearing be set for November 22nd at 8:45 before your honor.
Mr. Dillard, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond to assure your attendance at the next hearing on November 22nd, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I interviewed today at Stanley. I was celebrating last night, and then I ended up getting locked up. I knew my child support was getting high, and I was doing my best to apply for jobs, and I can't lose it, so I'm here, I guess, so I don't have any money.
Okay. Well, because it is your first bench warrant, I'm taking that into consideration. And you did pay in up to May. What I'm going to do is I'm going to reduce your bond to the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. Thank you, sir. You're free to go. Have a good day.
In the 18916 matter, this is the second bench warrant with bond currently set at $836. Mr. Eggleston failed to appear on October 12th of this year for a show cause before the referee. He reports he is self-employed. The last payments made in both matters were on April 8th of 2023. He made those payments on his own. In the 182-443 matter, this is the third bench warrant with bond currently set at $4,047. Again, he failed to appear on the 12th of October of this year for a show cause, and last payment was April 8th of 2023. Friend of the court requests in both matters the next hearing be set for November 22nd at 8:45 before your honor.
Okay, thank you. Mr. Eggleston, you're before the court a charge of civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 22nd, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, Your Honor.
Okay. Well, you do owe a sizable arrearage on these particular matters. On the first case, what I'm going to do is I'm going to set your bond in the amount of $200, and in the second, that's the 182-443. I'm setting that bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
I'm not going to postpone, Your Honor. I already got a for Oklahoma too.
Okay. Okay, we will see you back then on the 22nd. Have a good day. You're free to go. Thank you. Good morning to both of you. The court will note that this matter is before the court on the defendant's motion to determine child born out of wedlock. It's my understanding, Ms. Bolden, that you are currently pregnant and anticipated delivering sometime in April or right around April of is it? Oh, you put in your motion 2023. I assume you meant 20 of 24. Is that correct?
Yes.
Okay. I do note as well that, again, you stated that the two of you had separated back in November of 2022. The court had entered an order for DNA testing by error, typically when the parties are separated for that period of time, where there couldn't be any factual basis to find that the person is the parent. The court would not order DNA testing in this matter. So that order, I believe, has already gone out. You can disregard that order if you wish, because obviously it was entered in error. So what we're going to need to do is we're going to need to have an evidentiary hearing, because the court doesn't take testimony on Mondays. because I have a tremendous amount of cases scheduled and I couldn't take the time for testimony. So what we have to do is schedule this for a Wednesday afternoon hearing at 1:30, and we can take some brief testimony. It shouldn't take more than 15 minutes or so, and then we'll be able to conclude the case. So we'll get with both of you and see what works in your schedule for a Wednesday afternoon that you're both available. And then we will schedule the hearing at that time. Okay?
Okay.
Do you have any questions, Ms. Bolden?
No, sir.
Mr. Bolden, any questions?
No, sir.
And Ms. Bolden, if the alleged father, Mr. Pittman, is available on that date and you can get him to appear, that would be good because then we can establish paternity at that time.
Okay.
Okay? Thank you both. The court will end this matter at 9:02 a.m. You're free to go. Have a good day.
9:03
Thank you.
a.m.
Good
Thank
morning
you.
to everyone.
Good morning, Your Honor.
The court will note the appearance of Mr. Kelly on behalf of the plaintiff. This matter is before the court on the plaintiff's notice for entry of default judgment. I'll ask you, Mr. Perry, are you contesting or disputing anything in this matter?
Yes, sir.
Okay. Well, what's going to happen if you're going to do that, you're going to have to take some action because there's been a default entered in this case against you. So you're going to have to file a motion to set aside the default or take other action in this particular matter. You just can't simply sit back and wait as the matter progresses. So what the court's going to do, Mr. Kelly, in view of Mr. Perry stating that there's a dispute, I'm going to hold off on this matter for 1 week. That'll give Mr. Perry opportunity to file what he needs to file in this case. And if we don't receive anything, Mr. Perry, we will enter the order in 1 week, the judgment. And then if you do file something in that week, then we're going to have to take and address that at a subsequent hearing.
All right. Might I ask a question, sir? Your Honor?
You can. I can't give you any advice, but you can ask it.
I have multiple diagnosed mental disabilities. Like, I don't know what I'm supposed to do. Like, I'm by myself. I have no family.
Okay. That's not unlike other people. What you're going to have to do is you're going to have to do some research, or you'll have to contact an attorney and get some advice as to what you have to do. I can't give you advice as to what you have to do. Okay?
Okay.
Okay.
Your Honor, do I need to renotice this for next Monday?
No, what we'll do is if Mr. Perry doesn't file anything, we'll just enter it on that date. If he does, then presumably what he's going to have to do is he's going to have to notice it up. And then what we'll do is just hold this off until that date as well. So you don't have to do anything further, Mr. Kelly.
Okay, no further appearance.
No.
Okay, thank you, Your Honor.
Okay. Thank you. Court will end this matter at 9:05 a.m. You're free to go. Have a good day.
Thank you.
No problem. Thank you.
9:06 a.m.
Good morning to everyone. The court will note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Bartell on behalf of the defendant. This matter is before the court on the defendant's amended motion to expand parenting time. Mr. Bartell.
Thank you, Your Honor. This case all originated and led to my client, Mr. Baker, receiving supervised parenting time because of allegations that Mr. Baker had a physical altercation with one of Mr. Baker's stepchildren a few years ago and domestic violence charges. Originally, my client was given limited supervised parenting time with Bruce Sweet, and there were some exercise time periods of 1 hour in which we had provided an actual letter to opposing side that Mr. Sweet had nothing but positive reviews of the supervised visits with regards to Mr. Baker. He had noted that Mr. Baker was well connected with the children and they seemed very comfortable with him, and the interactions were positive and appropriate, with affection shown between the minor children and Mr. Baker. And he had indicated that the supervised parenting time should continue until the legal matters concerning the domestic violence were concluded. And at that time, when we had provided that to the other side, there was an agreement of expanded supervised parenting time to every Sunday for 6 hours with my client's mother, Paul Harris. Now, the criminal matter has concluded. My client is on probation still in Branch County. He's doing wonderful. There's no probation violations. He's doing everything asked of him. That matter has concluded, and the exercise parenting time that he has with the minor children are going well as currently. In fact, even though there is not a formal order that has been entered, plaintiff has allowed overnights now with defendant and the minor children. So we think at this time, it would be good to review this. We think that he should have expanded parenting time. I would note to the court, we had previously brought this motion months ago, and then all of a sudden, we received an email from plaintiff's counsel that stated, "Did you know that your client has a warrant out in Calhoun County?" Well, we withdrew the motion to investigate it. That was not, in fact, true. There was no warrant out. And that came about at the time of obviously us filing this motion. I think the court can read between the lines as to that. Further, my understanding is that in this particular matter, there has been some video that recently my client has obtained from some third party that believes he's getting railroaded in this matter. That has showed plaintiff sitting on one of the party's minor children in the last 2 years, in which she is physical with the child and she's allowing and laughing when the other minor children are hitting this other child. Whether this minor child is alluded to that in the answer as some disciplinary reaction, that is not an appropriate way to discipline your child by sitting on them, being physical with them, and allowing the other children to hit that child and laughing about it. Your Honor, it's pretty evident in this particular matter, plaintiff is going to do whatever she can to prohibit any expanded parenting time. I would like to point out, for example, that in paragraph 17, plaintiff admits that there are no issues with the supervised parenting time. Number two, she cannot agree that Mr. Sweet even had a positive outlook in regards to the connection or interactions between Mr. Baker and the minor children during the supervised parenting time. But there's a fact that that letter was provided to plaintiff and her counsel, and it's a fact that Mr. Sweet had indicated that in his letter, and yet she still cannot agree to that. So I think this, in this particular matter, Your Honor, I think it's appropriate for Mr. Baker to have expanded parenting time. Something needs to be put in place so that he can get to the point of unsupervised parenting time. And given the facts here, I think there's nothing that should stand in the way of that.
Okay, thank you. Ms. McNeff, what's your response?
Your Honor, as far as the warrant, my client did in fact believe that there was a warrant issued at that time, and she had spoken with somebody at the courthouse, and perhaps she received wrong information. But it was, if it wasn't true, it was a mistake. It was not an intentional misdirection by any means. My client has permitted Mr. Baker's mother to have the children for overnights. And Mr. Baker has been welcome to spend that time at his mother's house with her supervising that parenting time. So while it isn't true, it is not true that she's allowed Mr. Baker to take the children on his own overnight. It is true that she's allowed the children to be at his mother's and for him to spend that time with them so long as his mother is present. We understand that Mr. Baker is in probation. Our concern here is that it's been less than a year since he had an altercation with a girlfriend and had another domestic violence incident. It's been less than a year since he had a blow up with his mom over Christmas parenting time. We're concerned that he still hasn't really addressed any of his psychological problems or his anger management problems. In 2022, he confided in my client that he was having suicidal thoughts and homicidal thoughts. We don't believe that he's received any counseling to address whatever it was that was causing him to have those thoughts and have those concerns. We agree that Mr. Sweet did supervise the parenting time, but that was quite some time ago. And there were only 3 1-hour sessions. So watching somebody with their children for 1 hour is very different than someone having 4 small children for an entire weekend. We believe that if we are going to expand parenting time, and we don't have any objection to expanding parenting time to allow Mr. Baker an overnight, so long as that parenting time takes place in the home of his mother with his mother's supervision. We know that at one point at Christmas, she had refused to do the supervision due to the blow up, but we understand that at this point, she and Mr. Baker are now on better terms. And we believe that would be an appropriate way to handle parenting time at this point. Alternatively, Your Honor, I believe there may be a need for an evidentiary hearing on the issue.
Okay. Well, looks like we do have at least some softening, if you would, at this point. What the court will do, based upon the willingness to allow that overnight, the court will state that in the interim, on an alternating weekly basis, that the defendant can have overnight parenting time at his mother's home on alternating weekends from Saturday at approximately 9 o'clock until Sunday at 6 o'clock p.m. And what happens then, we'll just contact the attorneys and we'll schedule a evidentiary hearing, and we'll address the matter at that time. Mr. Bartel, you can prepare the interim order, and then we will get in touch with you. How long do you think you will need for a hearing? Will 1 day suffice, a half a day? What are you looking at, Mr. Bartel?
I wouldn't say more than a day.
I would agree with that.
Okay, we'll set it for 1 day, and then we'll get the notice out to you. But in the interim, we will award the alternating weekend overnight.
Okay, thank you, Your Honor.
Okay, thank you.
At 9:26 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to adjourn referee hearing, and also requesting various discovery. I guess I'll ask first, Mr. Suhaki, just in case, see if there is an issue. Why would it not be appropriate to adjourn the referee hearing if, again, the plaintiff is simply going to attend a event with the children or a child down in Disney World?
I didn't have any issues, Your Honor.
Okay. Okay, the court will grant the motion adjourning the referee hearing. Ms. McNiff, how much time are you going to need for discovery?
I don't need much time. I really just need to send a subpoena to Mr. Suhaki's employer to get income information.
Okay. You think you can have that done by end of December?
Oh, absolutely.
Okay. Why don't we do this? Why don't you put in the order that we're adjourning the referee hearing, and that'll be held after January 1 to allow the parties to engage in discovery.
Okay, that sounds great. And I think the address issue won't be a problem now that Mr. Suhaki will be using my address to correspond.
Okay. That's fine.
Your Honor, I assume the discovery will also be available to me
Yes,
on
yes.
his behalf.
Yes, you'll have until December 31st to do that. And but make sure you get it out right away, because it does take a while. They have a right to respond in 28 days. So you need to get that right out.
Your Honor, I would also like to request that I have that discovery available to both Megan's current and past employers over the last 18 months. Is that possible?
You can do anything you want in discovery. The court's not putting a limit on your discovery.
Thank you.
Okay. Thank you. Court will end this matter at 9:28 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Ms. McNiff on behalf of defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time support, and other relief. Ms. McNiff.
Your Honor, there is an update. There is a PPO currently now in this case that Ms. Moore filed against Mr. Moore. So that is in place, and there are carve outs so that they are able to communicate with regard to anything concerning the children, and they can be in each other's presence for the exchanges for the children or child related activities. So I think that does make a difference in terms of how this is handled. Your Honor, my client has found that it's been very difficult to organize parenting time in large part because Ms. Moore does have a very active schedule. In addition to working, she picks up a great deal of overtime shifts, and she's also going to school. And it's his position that he does not believe that she has the time to devote to the children during the week as he does. He works four days per week. He's off 3 days per week. He chose that schedule in order to be able to attend the party's oldest child's medical appointments that occur once a week. And he is able, in fact, to do that. From his perspective, he's providing the majority of the child care for the children during the week as a result of those additional shift pickups and school education that Ms. Moore is getting. So he is requesting primary physical custody with joint legal. The other major issue for my client is that Ms. Moore has a new friend. We would characterize that person as a boyfriend, and she has had that person overnight while the children are present. This is a fairly new separation for the parties. The children are little. We don't believe that it's appropriate for them to see that romantic relationship on overnights until such time as the parties are fully divorced. So we would ask for a prohibition against the boyfriend spending the night while the children are present. And we believe because the parties currently have a very right now almost equal. My client has been getting about 17 overnights per month. That she has plenty of time to pursue her social life when the children are with their father. We also are asking that the court order child support to be calculated pursuant to the guideline. Now that the PPO isn't in place, I think effectively Ms. Moore does have exclusive use of the marital home. Mr. Moore can't be there, so I believe that point is moot. And I think that Mr. Todd and I can continue to work on exchanging personal property with lists because that's going to be more difficult now with the PPO. But we are asking for a custody and parenting time and child support order at this point, so the parties have a better guideline to follow and some structure to their parenting time.
Okay. Mr. Todd, your response.
Thank you, Your Honor. Your Honor, in this particular case, the parties have been exercising equal parenting time since separation. At this point, it's 2.5 months. There's an established custodial environment with both parent. We don't believe that there's any reason to disturb that. In fact, because the parties 2-2-3 schedule, in essence, defendant's been 45 minutes late and picking up the children late and dropping them off early. So my client has actually exercised an hour more parenting time throughout the week. So she actually has more parenting time. There was a situation in October where my client took 3 days of overtime to try to facilitate to get the children what they needed and wanted for Christmas. But outside of that, the parties have been and continue to exercise the parenting time schedule outlined, where one party will have Monday and Tuesday, then Friday, Saturday, and Sunday, and then the following week, that party would have Wednesday and Thursday. So in essence, very much a 2-2-3 schedule, which equates to equal parenting time. And defendant was fine with this prior to Ms. Moore starting a new relationship. Once he found out about this, then his entire tune changed. And that is really the crux of this matter, is it's retaliatory in nature. It is a boyfriend. The plaintiff has discussed with the children that this is not somebody who's replacing your father or anything like that. She declines to have any romantic activity or involvement when the children are around. This particular individual does have children who are of similar age. So the children like to play together. Additionally, it's inevitable, in essence, the parties are going to start a new relationship. In terms of the issue with the plaintiff's schedule, defendant's not accurate with his schedule. I did outline in our answer what his actual schedule was, or what her actual schedule was. But regardless, the children are accustomed to the status quo parenting time of this 223 schedule, and it has been working out fine. In terms of the other issues, there is in fact a PPO now. We don't know whether or not the defendant is going to be charged criminally for any of the things that occurred in late October. So we're just going to kind of keep an eye on that. However, we don't believe that there's any reason to disturb the status quo, and respectfully request the parties continue joint legal, joint physical custody, parenting time in that kind of 223 schedule.
Okay, thank you. Ms. McNiff, what do you say with regard to the 223 schedule?
I think given the children's ages, that would make more sense than an alternating week schedule, so that they wouldn't be spending 7 days without seeing either parent.
Okay. Well, the court has heard the arguments in this matter, as well as reading all the pleadings. The court will grant joint legal and joint physical custody, and the court will incorporate Mr. Todd's recommendation that we continue the 223 schedule in this matter. The children are very young, and that makes sense to do. The court would also grant child support consistent with the child support formula and guidelines in this matter, and I'll have that commence on today's date. And Ms. McNiff, I'll have you prepare the order and submit it under 7-day notice of entry.
Thank you, Your Honor.
Okay, thank you. Have a good day.
Your Honor, I apologize. One thing, and I don't know whether or not the court wants to do this. There is a scheduling conference set for next week. I didn't know if you wanted to just keep that on or knock that out.
I can. I've got like 5 hearings at the same time, so
Absolutely.
I have to get to those. Okay, thanks.
Thank you, Your Honor.
Court
Thanks,
will
Your Honor.
note that this matter is before the court on the defendant's motion to modify custody and support. In this matter, the defendant claims she was not served for the hearing on 10/16/2023. Ms. Ward, you can proceed.
Okay, so in this matter, I did get to speak to you on October 16th. You gave me 1 week, which was 7 days from that court date to mail off my objections if I had any, and I did just that. I did not know that I could email my objections or motions until a later date, but I did everything return receipt requested so that way I could track everything. Unfortunately, I don't know what happened once my mail got to Michigan, but it was never received by the court. I am requesting the court lift the ex parte order that's preventing me from taking my kids out of the state. I do verbally communicate everything with Mr. Ward, even prior to me leaving. He knew every step of the way, what I was doing, how I was doing it. I really don't know where the accusations of me not being present or participating in this matter came about, but as far as October 16th court date, I did contact the court because I did not get any paperwork from his attorney until after October. Now she may have mailed it off. I think it was like September 26th when I looked at her paperwork. When I finally got it in an email, September 22nd, because I had him email me everything. But I have reminded Mr. Ward July 7th, August 20th, August 31st, all the way up until the court date of October 16th, that I had to have a P.O. box added to my address. So that way I could be served correctly because I live in a rural town in Colorado. So, and that's just how the mail system works here. I don't know how else to explain that. Because it was stated in Mrs. Reed's objection to my motion to be brought before you that I did not contact them. And I do have proof that I have contacted not only him, but his attorney multiple times since July 25th, according to my phone records. And never once has Mrs. Reed or Mr. Ward spoken to me about a parenting plan, about any of the court paperwork. I've always left a message. So, and I've always given them my phone number.
Let me check, Judge, to see if Jennifer Reed is supposed to be in this hearing. I have her as pro per.
Okay.
She said she's in the waiting room.
I'm here.
Okay.
Oh, sorry.
And yeah, I have always let Mr. Ward in on what I was doing, how I was doing it. It was the day before I was to leave for Colorado that Mr. Ward filed an ex parte order. So the fact that he said he didn't know what I was doing or how I was doing it is completely false to the court. And I don't know. I really don't know what else to say. I didn't answer because everything that was in the paperwork, in the original paperwork that I got, I agreed to. Because it was joint custody, everything else was good to go. And then I got the paperwork for default, and all of a sudden I wasn't given that. All of a sudden I went from joint custody in the original paperwork down to 42 nights. I have been an active parent since I was 17 years old, so 42 nights is not okay with me. I am their main homeschooling parent. I pay for the homeschool. They call me when they're sick. You know, I have had contact with my kids every day since I have left, except when Mr. Ward did not want to answer his phone, which is why I bought them Gizmo watches to begin with. And I pay for those as well. So there's really not anything that is going to come out of his pocket as far as their schooling or, you know, their communication back and forth. And I don't feel that my parenting plan is unreasonable because I'm not seeking to take anybody's rights away or seeking to give them less than what is fair, which is half time. And I am off 7 or 6 months a year. So I do have the ability to keep my kids, you know, jointly.
Anything else?
Huh?
Anything else?
Not at this time. I mean, I really don't have any objections to anything else other than parenting time. I feel like we should split the cost of the children when they're in our care, both keep insurance, etc. My kids have been homeschooled for 3 years. So to change up my son's routine, and he's autistic, would be kind of detrimental to him and his mental health. And he's done really well. He has I want to say 2 bad grades that are below a 70 and a 70 in the last 3 years. He's already done with his 6th grade curriculum. So he'll be starting his 7th grade after the holidays. So, and I have an 18-year-old daughter that just graduated with honors. She's fantastic. She's 18 years old and, you know.
Okay, let me
No,
go
I
to
don't
Ms.
have
Reed.
anything else.
Ms.
Huh?
Reed, what's your response?
Our response, Your Honor, is the defendant was properly served by personal service on June 12th. She was served with a default request and entry on July 21st. She was then served pursuant to MCR 3.210 paren 4 paren A with the notice of hearing, notice of entry, and the proposed judgment of divorce on the September 12th. To her address. Then again, we served her to the P.O. box on September 26th. Both of those were properly served. She just testified she received that paperwork. We were here at October 16th at that hearing where Your Honor gave her 7 days to file a motion to set aside the default. She failed to do that. And what it appears she has done has grabbed every scale form available and tried to file that. All of those scale forms are improper. The default judgment of divorce has been entered. There is no proper cause or change in circumstance pursuant to Vadvarka or Shade to modify custody or parenting time. She does have reasonable parenting time considering that she is in Colorado and out of state. It's my client's intention to enroll these children into school. She has not had contact in-person parenting time with these children in the last 6 months when she's had the ability to do so. And it would be a disruption to have them 6 months in one state, 6 months in another, trying to facilitate school as well as activities. So we're requesting that her request be denied, and we're also requesting attorney's fees.
Okay, thank you. Ms. Ward, any response?
Yes, I actually do contact my kids every single day. Every day. I pay for their phone bill. So I don't understand where that is going. I filed every motion that I could file. Yes, that is true. But I did mail out everything the same day that I was told to.
Okay.
So.
Okay, well, in this particular matter, the court would note that parties in these cases are responsible for filing paperwork and filing it properly. I don't know what happened in this particular matter, but the court did, as of the September 16th date, give you that additional time to file. And apparently it was not filed in the appropriate time. And as I would have stated at that time, if it's not filed, the court will enter the judgment as submitted. I would note the proof of service on the judgment does show that it was sent to the post office box on 9/26/23. The court also notified you, and proof of service of the pro confesso hearing was sent to the post office box on 9/20/2023. And the court does note that service in this matter does appear to be proper all along in this particular case. And I guess the court doesn't see that there is a basis at this point for, again, granting the motion. The court is going to therefore deny the motion at this time, and that will conclude the case. Ms. Reed, I'll ask that you do a order denying the motion. I'm not going to grant any attorney fees at this time, and that will be the order of the court. The court will end this matter at 10:33 a.m. You're free to go. Have a good day.
Thank you.
23 at 10:35 a.m.
Thank you.
Court will note that this matter is before the court on the defendant's motion to set aside default. Mr. Luke, had you had a chance to review those pleadings as it relates to the default setting aside?
Yes, Your Honor, I have.
Okay. You note that the defendant states that she was, in fact, not at her mother's house on the 9/15/23 date, in which it claims that she was served. What is your response to that?
Your Honor, I think we should set aside the default and allow the defendant enough time to file a written response. But at the same time, I ask the court to enter a temporary custody order without child support, establishing unsupervised parental time. With the proposed order no later than 12 p.m. pickup drop off on Monday through Wednesday until no later than 12 p.m. pickup drop off on Thursday through Sunday, and that weekends alternate Saturday no later than 12 p.m. pickup drop off, and Sunday no later than 6 p.m. pickup drop off. I ask the court to adjourn this matter for 45 days to allow both parties to establish a mutual agreement. If we cannot find common grounds to resolve this, then I will move forward with retaining counsel, and he will file a notice of appearance shortly.
Okay. Ms. Moore, you've heard the statement stated by Mr. Luke. Is that acceptable to you?
No, it is not.
Okay.
Your Honor, I am asking you to set aside the default for 2 reasons. I was not personally served the complaint at the time of the proof of service. I was in Calhoun County with my aunt, and we were packing up mine and Summer's belongings, which is our daughter. She is here.
You don't need to address that. Mr. Luke said he's agreeable to set aside the default. So
okay.
extraneous conversation.
Well, the second reason would be because the case was improperly filed in Calhoun County. The law states that the case should be filed in the county where the child resides. In the pleading the plaintiff filed, he stated Summer lives at 9583 Astor Court in Northville, Michigan. So he knew that Summer was not living in Calhoun County, but he filed in Calhoun County anyways. At the time that this was filed, Summer and I had been living in Washtenaw County for more than 20 days. So Your Honor, I am respectfully asking you to set aside this default and dismiss the case.
I'm not going to dismiss the case because that issue is not before the court today. I can't just grab issues out of the clear air and address those. You're going to have to file a motion, and then we're going to have a hearing, allows the other party to respond. So I'm not going to do that just at this particular point. I will set aside the default because the plaintiff has agreed that that would happen in this matter. What I'm going to do is, at this point, because that's the matter before the court, is to set aside the default. I'll set aside the default. Ms. Moore, you're going to have to prepare an order, submit it under a 7-day notice of entry, setting aside the default. And then all the other issues can be brought before the court pursuant to a motion. So, Mr. Luke, you can bring your motion for custody and all those other issues. You can bring those up at that time. And Ms. Moore, you can bring up the other issues as it relates to venue as well. So that's, and we'll hear those at the time that they're properly before the court. So that's all that the court is going to do today. We'll end this hearing at 10:38 a.m. Ms. Moore, you'll have to get that in within 7 days, or otherwise you'll have to notice it up for a hearing and have a hearing on the entry of your order. So.
Thank you, Your Honor. I will file a motion to transfer or dismiss. Thank you.
Okay. That's fine, and but get the order into us so that we can take care of the default issue, because you can't file anything else until you've got set aside the default. Okay? Okay. Thank you. Court will end this matter at 10:39 a.m. You're free to go. Have a good day.
Thank you.
Court will note that the defendant has filed a motion to show cause in this matter, claiming that that the plaintiff has failed to communicate utilizing the Our Family Wizard or communicate in this matter. Ms. Herrick, are you disputing his allegations?
Yes, absolutely. I'm always readily able to communicate with him regarding my son. We are now on a good open communication. When we haven't been before, he would abuse the line of communication towards me, and I would have to kind of guard that and keep him from being able to do that for, just to protect myself from abuse, basically. But so that was the only thing before. I definitely am in communication with Justin and ready for any messaging or communication that we need to for my son.
Well, what happens if the court previously had ordered that you communicate through Our Family Wizard, that's the order of the court, and that's what you're going to have to do, regardless of what, maybe the situation is at the current time. As long as that order is in place, then the court will enforce that order. So what you're going to have to do is you're going to either have to agree and, vacate that order, or you're going to have to communicate in that particular manner. As long as she's disputing the allegations, the court's going to have a hearing in this particular matter where we take some testimony. So what happens? Go ahead.
Well, I can agree to the fact I haven't used the app. We tried that, and I thought that the messaging wouldn't be the same on there as it is on my personal line, and it was. So then we kind of just haven't used that. But if that's the only issue, and it would skip the hearing or make it easier and faster for me to just agree to talk to him on the app, I would do that.
Well, let's look at it this way. As I stated, that's the order of the court. You have to follow the order of the court as long as it's in place. You can't agree unilaterally to just decide and do something else that's not an order. You can agree to something, and then we can get an order in place. We could have got an order that would eliminate the Our Family Wizard communication and allow you to communicate another way, but you've got to do it by order, or we end up in situations like this where somebody's complaining somebody hasn't done something, and that's again open to a finding of contempt. So as long as the order's in place, you have to comply with the order. Mr. Beers, is there anything else you would like to say?
Yeah, she also transferred him schools without my consent.
Okay.
That goes against the court order as well.
Okay. Well, what we're going to have to do in this regard, we're going to have a hearing. So the court's going to send the matter to a referee for a hearing on the contempt and the show cause. And then the referee will contact you and probably within about a week with a date for that particular hearing. Then you'll have to show up at that hearing and present any of your evidence and proofs, testimony, et cetera. And then the referee will make a determination at that time. So that's what the court will do today. The court will end this matter at 10:43 a.m. You're free to go. Have a good day. Good morning, Mr. Elliott Wiley. How are you?
Good. How are you, sir?
Good. This matter is before the court on the defendant's motion to transfer the case. He wishes to transfer the matter to Berrien County. You do comply with the terms of the court rules in this matter. You state that all the parties reside in other counties. You stated that plaintiff resides in Berrien County and has for 6 months. And the court would note that Berrien County is not contiguous to Calhoun County. So pursuant to court rule, transfer to Berrien County would be appropriate, provided that they accept the transfer, sir. I can't simply transfer it because you want to transfer it. They have to accept it as well.
Okay.
Okay. What you're going to have to do, because you filed this action, you're going to have to do an order of transfer. I don't know if you've been using a service such as MichiganLegalHelp.org or something. Have you used that?
No, I haven't been using that. I've kind of been going to the offices back and forth and just getting the help that I can.
Okay. Well, if you go to MichiganLegalHelp.org, they'll have all the forms on file.
Okay.
And so all you have to do is, because you filed your motion to transfer, go to that and there you'd get an order of transfer, which would be the appropriate state court administrator office order. And then you can file that. Court will allow you to do that and submit under a 7-day notice of entry. So you're going to have to get that in within 7 days of today's date, or otherwise you'll have to schedule the matter up for an entry at a different Monday. So at this point, if you get it in within 7 days, you don't have to notice it up for entry.
We have an order. I'm not sure. Let me look at the order. He filed an order.
Oh, okay. You filed the order then, sir.
Yeah, so I think I
Changing venue and transferring case post judgment.
Okay. Well, you've done what you need to do then. We can get that order entered today. And
Awesome.
Then it's subject to, Berrien County doesn't take it, then you're stuck in Calhoun County. But if they accept the transfer, and I don't know any reason that they wouldn't, but if they accept it, then you'll have to file any actions over in Berrien County at this point. Okay?
Yes, sir. Thank you.
Okay, thank you.
Yes,
We'll
sir.
end this matter at 10:47 a.m. You have a good day, sir.
Attorney Alicia Storm for plaintiff and Attorney Ives for defendant.
Good afternoon to everyone. This matter is before the court for a settlement conference. I've been apprised that the case was not settled. And is that the state of affairs at this point, Ms. Storm?
Yes.
Ms. Ives?
Yes, Your Honor.
Okay. So it looks like we're going to have to schedule the matter for trial. Ms. Storm, how long do you think you'll need for a trial in this matter?
Your Honor, if I may interrupt, I think we already were given a date. Your assistant, Christy, called us both and had wanted to get those dates set. So I think we have a trial date already set in stone.
Well,
yes, we do. I missed that. December 7th.
Court appreciates that the staff is so efficient then.
Thank you. I appreciate Ms. Ives interjecting because that saved me from having to say it.
Okay. Well, that's good. Okay, so it looks like we do have a trial date set in this matter. So we'll proceed then to that date and get the matter hopefully resolved at that time.
And I just want to confirm, if I may, Your Honor, that the court would like actual hard copies of the exhibits delivered to your office at least 7 days before?
Correct.
Okay. So no visual sharing on the screen.
Well,
Everyone has their own copy of exhibits.
You can do that at the time of the hearing if you don't want to share screen stuff. I like the copies because what I do is I refer back to them at different times or as I'm preparing the finding, and it's harder to get those out, especially if they're lengthy. So I like the hard copies so that we have that for purposes of the ruling.
Thank you. Does the court require a witness list as well to be filed?
Well, if you look at your case scheduling order, it says in there that the witness list and the exhibit list would be disclosed no later than 21 days after the first mediation date. And so I'll tell you, if in fact they are disclosed after that date, the court will not allow either the witnesses or the exhibits to be introduced at trial if it doesn't comply with the case scheduling order.
Okay,
So,
thank you.
okay. Anything else, Ms. Storm?
Just that we have, of course, a few Thanksgiving coming up in between now and then, and any other holidays. Should the parties just be expected to follow the Calhoun policy as written?
Do we have an order in place at the current time?
We have an order for parenting time, but I think we neglected to put holidays in there by oversight.
Okay. Ms. Ives, is that accurate?
I would believe so. I think my client would like Danielle, if you could confirm, would you like to have the parenting time, the Calhoun standard implemented?
Yes.
Okay. So, Ms. Storm, I guess because you brought up, I'll ask you would at least prepare a quick order that would just state that the parties will follow the standard holiday parenting time. And I don't know which of the parties had, let's say the last one, which would have been Labor Day, but we'll alternate off that. Whoever had that date will alternate off that date.
Okay.
Okay.
So who did have? I think Mr. Ward had Labor Day. Can you confirm, Ms. Storm?
Parties ended up sharing it. They each got half the weekend, so it really kind of ended up being a wash.
Okay. Well, let's go back to the one before that. Who had the 4th of July then?
Who had 4th of July?
Oh, we did.
My client had 4th of July.
Okay. Then we'll alternate off that date then.
Okay, sounds good.
Okay.
Danielle, you would get Thanksgiving then.
Okay.
Okay, thank you.
Well, let's
As
clarify.
I say, I don't know if that's
If we alternate
accurate.
off of the 4th of July, she doesn't get Thanksgiving.
Correct. My client would.
Okay.
Okay.
Yep,
Okay.
that's true.
Thank you. The court will end this matter at 1:49 p.m. We'll just see you on the scheduled trial date then.
50 p.m.
Thank you, everyone.
Good afternoon to both of you.
Good afternoon.
Court has been apprised that you did get this matter settled at mediation. Ms. Johnson, is that accurate?
Yes, it is.
And Mr. Johnson, is that your understanding as well?
Yes, sir.
Okay. I did have a note in this matter that defendant had not paid his mediation fee. Have you paid that yet, sir?
Yes, sir.
Okay. We will basically attempt to confirm that with the mediator. And I will tell you that what happens if it's not been paid, the court will not conclude the case until such time as that has been paid, but sounds like you've taken care of it at this point. Ma'am, what we'll do is I will take some testimony from you at this time. And so if you would you raise your right hand? We'll have you sworn in and then we'll proceed.
Oh, so that's this one.
Ma'am, do you solemnly swear
When
or
you filed your
affirm?
complaint, you stated that you had resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing of the complaint. Is that correct?
Yes, it is.
And in this matter, are all of the allegations in the complaint true at the time you filed it, and are they true today?
Yes, they were.
Are you currently pregnant?
No, I'm not.
You state in the complaint that there has been a breakdown of the marital relationship to the extent the object of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
Yes, it is.
If the court did not see fit to grant the judgment of divorce, is there any chance that you and the defendant could reconcile and live together as husband and wife?
No, I don't believe so.
Thank you. The court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. At this point, I don't know what you're doing, ma'am, because you're the plaintiff. Have you been working on preparing a proposed judgment of divorce and a uniform child support order?
I actually believe that I already submitted all of that.
Okay. You may have submitted to the front of the court. We just don't know because we don't get anything until after they approve it. So,
Well, I know the initial one was approved, but after mediation, I submitted new papers for an adjustment for what we agreed to.
okay. Okay. Well, we'll wait to, you still have a period of time, just under 2 months for the waiting period because we have a 180-day waiting period. So we've got time to get that in. As soon as we get that approval from the front of the court, we will put it on our calendar for that 181st day, and then we will enter the judgment in the UCSO at that time. So you're not divorced until I actually sign that. And then once we sign it, then that will conclude the case. You will be divorced at that time. Any questions, Ms. Johnson?
No, I don't have any questions.
Okay, thank you. Mr. Johnson?
Yes, sir.
Okay. Well, you're excused at this point. Have a good day, and hopefully we'll get that in and get that taken care of relatively soon.
Okay, thank you.
At
Good luck to both.
1:54 p.m. Attorney Jennifer Reed for defendant.
Okay. Good afternoon to all of you. Court will note that I did receive a notice that the mediation was canceled as the plaintiff failed to contact or pay the mediator. Is that accurate, Ms. Reed?
That is accurate, Your Honor, but we have reached an agreement on all issues. We have a signed judgment of divorce and child support order that is with FOC for approval, so we may proceed to preserve proofs.
Okay, thank you. Is that accurate, Mr. Northrup, that you do have a resolution in the case?
Yes.
Okay. Mr. Northrup, in this matter, you filed a complaint for divorce, seeking a divorce from the defendant. And at the time that you filed that complaint, had you resided in the county of Calhoun in the state of Michigan for more than 180 days immediately preceding the filing?
Yes.
And in this matter, all the allegations in the complaint, were they true at the time you signed it, and are they true today?
Yes.
You state that there has been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that correct?
Yes.
If the court did not see fit to grant a judgment of divorce, is there any chance that you and the plaintiff defendant could reconcile and live together as husband and wife?
Probably not.
Okay. And in this matter, do you know, is the defendant currently pregnant?
No.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter. You will not be divorced until I actually sign that judgment. We still have a little bit of time to wait, just about a month and a half. So at that time, once that time is run and we have approvals from the front of the court, then we will be able to conclude the case. You will then be divorced at that time. So best of luck to both of you. I hope everything works out for you. And you're free to go. Have a good day.
All right.
Thank you.
Thank you.
Thank you.